Dear colleagues, we continue our working day at Ukraine Crisis Media Center. The topic of the press briefing is presentation of draft law and amendments to several legislative acts of Ukraine on seizure of unexplained assets in favor of the state. And our guests are Pavlo, Petrenko, Minister of Justice, Anton, Geraschenko, the People's Deputy, Dovydas Vitkauskas, Coordinator of EU Project Support of Justice Sector Reforms in Ukraine, Karl Volokh, activist, and Anton Yanchuk, Deputy Head of the Minister of Justice of Ukraine. Welcome on stage. First, the floor is given to the Minister. Good afternoon, dear friends. Before presentation, I would like to remind you about the history. During two different estimates of the experts and law enforcement bodies, the regime of Yanukovych for 4 years, they stole from the budget 20 or 30 billion of dollars. And this can be seen from direct and indirect indicators. The situation that was at the beginning of 2014, when there was a gap in the budget. There were many billions that were in the accounts of local government and in the accounts of general fund of state budget, but there were no such funds there. So there was large-scale corruption of siphoning the money away from the state budget. And it is impressing, and of course, there was clear requirement for the law enforcement system to return this money to the state budget, those money that was siphoned away by Yanukovych gang. This money is in Ukrainian banks, and I would like to remind that in 2014 there were arrests of $1.5 billion of the United States at the accounts of offshore companies that were registered in the state and national banks and in other countries. And it happened so that the law enforcement system of Ukraine faced with new challenges when the people left the country, and despite all treaties, they refused to send us people back, and we had to adopt a new law for Ukraine. This is special confiscation and civil confiscation of the assets that were illegally obtained. So the system after revolution was weak, and a lot of people working in law enforcement bodies were appointed by Yanukovych gang, and the weak situation in the justice system didn't provide the results Ukrainian society waits for. Also, Ukrainian parliament that during a year made attempts to adopt the law on special confiscation that would bring the first part, $1.5 billion of dollars that are now in Ukrainian banks. For 8 times they voted for draft laws developed by the deputies, and faction United People's Front said that they should adopt these laws. But despite this, a lot of forces in the parliament, they had different grounds why they didn't vote for this law, and as of today in Ukraine we do not have special confiscation regime that would allow to return this money to the state budget. The Ministry of Justice of Ukraine, at the request of the government this spring, was included in this process, and we started to lift those manipulations that were made by the deputies and pseudo-experts that defended the money of Yanukovych. I would like to thank our colleagues from EU project that together with us they joined this work, and I would like to thank a working group of the representatives of people's the deputies and Anton Geraschenko. We worked on the draft law, the new version. The previous versions could have become laws, but in this draft we we get rid of all speculations and in the civil process, and this law, I believe, this draft law should become a law in the nearest future, in next week. Yesterday, the government of Ukraine approved this draft law, and the experts of the EU Commission also provided their endorsement on this draft law, and all the myths were dismantled, and this draft law adheres to all the norms that are in the European Union, and our task is that Ukrainian law enforcers had the instrument to bring this money back, to recover this money that are in Ukraine, and also the existence of such institution that meet European standards that will help us by getting decisions of Ukrainian court to send these decisions to the country. We had special convention with to the EU countries, and to get those assets that were frozen in that country, and this money would be brought back to Ukrainian state. And because of inactivity of law enforcement bodies, the money are sent to the national budgets, not to Ukraine, and they are not sent back to Ukraine to people who suffered because of this corrupt schemes. That's why I asked the representative of the media to follow the events of the voting of the people's deputies that will be next week, and also to help us to dismantle the myths and speculations that are around this draft law. And this draft law will become a law, and this money will be returned to the budget. And in more detail about these procedures, one of the co-authors of the draft law, Mr. Yanchuk, will tell us about it, and I would like to thank him for his work and the creation of such a product that is now a draft law. Thank you. Thank you, Mr. Minister. And now I give the floor to Mr. Anton Geraschenko. Good afternoon, dear colleagues. This law is necessary for our country to continue fighting corruption that was started after the Revolution of Dignity. Why this law is important to the legal system of our state. There are some cases when top people who involved in corruption, they didn't register the assets on themselves, and these assets were registered as the property of the subordinates. And it was impossible to say that these assets were obtained illegally. And in Italy, when they fought mafia in 1970s, the head of mafia was some elderly person. He didn't have anything, but his proxies had millions. So when the Italian government adopted the law, when a person who has big money or bonds or property and cannot say where this came from, the state have the right to ask through the court to explain the origin of this assets. If this person could explain that that was the credit or loan from that who have legal grounds for this, then the assets remained with this person. And if they couldn't explain the origin of this asset, why, for example, they have a villa or a multi-million-dollar account, so the courts took decision to seize these assets. This person was not brought to the criminal responsibility, but they lose the access to these assets. And the Italian police did everything to prevent robbing of people, because they after this, 30 countries adopted this legislation that is used for fighting corruption and trafficking of drugs. When some people who are unemployed, for example, in England, could earn millions of pounds, but it was impossible to identify how they did it. But the court asked them how could it happen that they had luxurious goods without any profit. If they couldn't explain, this property or assets were seized. And we started to develop such draft law, and there was a great counteraction from the side of lawyers and some deputies from the Supreme Council and the media. Why? So on the accounts of the Ukrainian banks, 1.5 billion assets frozen. There's assets that are in the offshore company, and in Yanukovych time, they wanted to buy state bonds, and the law enforcers say that this is part of the assets that were brought away from the state budget of Ukraine, but it was impossible to prove that the director, for example, of some Panama company is criminal. It was difficult. That's why they decided to adopt such a law, and the state could, through the prosecutor's office, to address civil court and to ask the representatives of such a offshore company where did they get these assets from. So if they took the loan, there is no question the decision will be in their favor. But if there is no good explanation, the court will take this money to the state budget. So also there was some counteraction to the against the deputies who promoted this law in the parliament. And I would like to give the example of Latvia. We knew that Latvian court got 50 million euros to the state budget from the accounts of questionable companies. The court addressed the companies. They couldn't get proper answer, and they brought this money to the state budget. And also there are some declarations that this is wrong, this is illegal, that it won't be considered by the European Court on Human Rights, but the court adheres to the law, and it took decision in favor of the state in such cases. Also, as the Minister of Justice, Pavlo Petrenko, I addressed to the media to follow who will comment and how these comments will be made and what factions of the deputies will vote for this law or against it. And those who won't vote for this, these are people who do not want to have fight against corruption here, to prevent this criminal to have the illegal assets. So I give the floor to Dovydas Vitkauskas, please.
To be here and to represent our project, which is financed by the European Union. I speak in my capacity as an expert and on behalf of other experts of our project. Of course, we don't have the mandate to speak on behalf of EU, but we are a project financed by EU, so we are trying to help the Ministry of Justice and our stakeholders to the best of our capacities, to the best of our abilities. It's a great pleasure also for us to be involved in the development of this draft law together with the Ministry of Justice. We're trying to work in a constructive way, trying to discuss the differences before and not after the draft is prepared, and I think this is one of the rare examples and very good constructive examples where this sort of preventive and collaborative work together has taken place. Ukraine, as well as many advanced jurisdictions in Europe, United States, is facing a great problem of dealing with proceeds of crime. According to various estimates by World Bank and other observers, the proceeds deriving from crime, not only corruption, but organized crime in particular, amount to hundreds of billions of dollars per year. For instance, a country like Italy, according to some estimates, has a number of $100 billion per year of proceeds of crime. These are the numbers that, of course, could be disputed, but they show the vast difference between, on the one hand, the financial gain that the criminal activity is generating, on the other hand, our ability, the state's ability to deal with these issues. By contrast, the amount of assets actually confiscated even in jurisdictions such as Italy, which is, as has been said by the previous speaker, is a rather creative and innovative state for dealing with proceeds of crime, amounts to hundreds or thousands times less than the estimated amount of the actual proceeds of crime. This means that all the jurisdictions should look for more effective ways of dealing with this phenomena of financial gain. Italy, United Kingdom, Nordic jurisdictions, many other European Union jurisdictions have already designed tools very similar to the one which is being proposed here by the Ministry of Justice. This is called non-conviction-based confiscation. This is a tool that is targeted at assets as a preventive measure, as a measure which is targeted not to punish a person for an offense, but to act as a discouraging tool, to take away the very motive, the very reason for offending. And of course, corruption is not the only offense, suspected offense, with regard to which these tools are being applied. Organized crime offenses, in particular drug-related offenses, but also money laundering, terrorism financing, serious financial offenses could also be included in this category. As I mentioned, we worked together with the Ministry of Justice since spring this year in order to work on various differences, in order to come to a more concerted approach on this legislative proposal. In the meantime, as you know, there were other attempts in Parliament to deal with the same issue. We, together with the European Union delegation, whom we advised, opposed seriously the previous attempts simply because they did not strike a fair balance between the interest of crime prevention on the one hand and the interest of protection of property rights and fair trial on the other hand. We believe that this current draft is a very good way forward towards much better balance between these two competing interests, crime prevention and fair trial and property rights. There are, of course, some differences with regard to the text of the draft. However, we are very happy that the Ministry of Justice in particular has decided to introduce standards of proof as one of the most advanced and most effective ways of ensuring greater clarity and foreseeability in the process. Standards of proof allow parties to know in advance to what extent they have to provide evidence, what sort of evidence they have to provide. Standards of proof restrict the discretion of the law enforcement bodies and they restrict the discretion of the judiciary to take decisions on the basis of, let's say, arbitrary assessment, of untransparent and opaque assessment of the evidence. So standards of proof and introduction of standards of proof in particular, in our opinion, will be a rocket that will really bring forward much more clarity to the Ukrainian legal system and criminal process in particular. Having said that, of course, we see that there are still some issues with capacity of the justice sector, with the capacity of law enforcement. These issues need to be resolved. Of course, the Asset Recovery and Management Office needs to be operational. Criminal investigative bodies need to develop their capacities to focus on assets, on tracking serious and complicated movements of money and financial and focus more on financial aspects of investigation. International cooperation between law enforcement bodies is essential. We all understand that proceeds of crime is a global phenomenon. It also partly is the result of the globalization. This also means that the states have to work together to track assets, to seize them, to confiscate them. They have to have agreements in order to participate in processes in other countries. They have to have agreements to share the assets once the confiscation takes place. So our position in discussions with the Ministry of Justice is the text is okay, and of course it should bring much benefit to the Ukrainian legal system, but at the same time we still have to work together to improve capacities of law enforcement and justice sector, and in particular to develop the international cooperation mechanisms which will be essential in order to have an effective and efficient asset recovery regime. Thank you.
Дякую, пане Vitkauskas. До слова запрошується пан Карл Volokh.
Доброго дня.
Good afternoon. For the previous year,
or more than a year, I took part in drafting 4 or 5 texts of this bill, but all previous attempts failed, unfortunately. But it seems that we considered all the main gaps which we had in previous drafts of this bill. We took into consideration all those issues which allowed our opponents to criticize us. So now you can see the title of this draft law. And the second, we now do not have something common with those figures who were previously blamed that they have individual interest, personal interests in this law adoption, and all those comments that this law is not pro-European, that it is contradictory to the Constitution and international conventions, that the decisions of Ukrainian courts will be rejected by the European Court of Human Rights. All those allegations, they are not any longer true. So the MPs who dislike this bill very much for the reason that they are afraid this mechanism will address them individually, or those MPs who lobby the interests of those persons who fled to Russia. We hope that we have done our best, and thanks to international experts as well, and the team of MPs headed by Anton Geraschenko, we have done our best for this law to be passed this time, to be enacted. There are some shortcomings in it. For example, I think that it is an important shortcoming that the scope of this law, the scope of its application is a little bit narrow as it was in previous versions. This is about backward presumption, when a person starts to explain where it has got the assets from. This concerns those persons who fled. We would like to use the instrument, the tool in fighting corruption, of backward corruption. We would like it we would like to include it further into the bill. This is the comment also on the part of our international expert. I think that with time, when this law has already been adopted and when it will work for some period, then we can convince the MPs to expand the scope of the law. Well, yes, we really narrowed the scope, but this is the need. We should have done that because the assets, we should recover to the budget at least those assets which are recoverable now. And we also narrowed the scope in order to convince the deputies to vote for this bill. I'm giving the floor to Mr. Anton Yanchuk. Good afternoon, dear ladies and gentlemen, and I will start with the presumption which is 1,000 years old. This is about social relations which goes ahead of development of legislation, and legislation can't keep with the pace. And that is demonstrated in this situation. Yes, Ukraine has the tool of concentration in its legislation and special confiscation as well, but at the same time, there are cases of social relations which do not fall into the scope of those tools. That is why the development of new third tool emerged. We should fill this gap in the legislation. The bills, there were 4 wordings of this bill. This just proves that this regulation is a must, because 4 previous draft laws, they failed. The MPs didn't vote for them. The Ministry of Justice and European experts we took not the novel approach, but the best practice approach. The World Bank, its initiative titled STAR, provided recommendations how to form the legislation on assets recovery out of trial. These recommendations are available and they compile 400 pages in 10 languages, including Russian. This practical guide was taken as a base when this draft law was prepared. The Ministry of Justice and the MPs took part in the process of writing this bill, because the MPs will have to vote for them soon. And we also invited international experts who know the practices of implementation of the same kind of initiatives. And now the draft law is already half-year old, and it was provided positive opinion of the European experts and positive opinion of the General Prosecutor's Office of Ukraine, which will be the main implementing body of this law. Now we have the product, which in general is acceptable for all stakeholders. So the next step is voting for it, adopting it in the Verkhovna Rada. The principal difference of this tool from the previous initiatives is in that this instrument is less risky than previous bills. The whole process of seizure of unexplained assets will be in civil proceedings, where the prosecutor's office files civil suits. And then the defendant can explain where he got those assets from. The second issue, the scope of the bill, of its subject matter, has been narrowed. Yes, indeed, it is applicable only to very limited scope of assets which could be transferred very easily. For example, money on accounts, they could be converted in and also value foreign exchange currency accounts or securities. Criminals can siphon off such assets which are easily convertible. They could be easily siphoned off by criminals from the countries. The scope of subjects who are entitled to submit the suits, it has also been narrowed. And also transparent rules what the person should explain also is envisaged, as well as the right for appeals and other measures dispelling the myth that this this mechanism can be used for unlawful purposes. We also are sure that so far this product is evolutionary, more perfect, more proper than previous versions, and we hope it has all the chances to be adopted. Thank you.
Thank you, Anton. Thank you, dear colleagues. Now the questions, be brief. Introduce yourself. So, Mr. Minister, and those who are present here, if they won't vote, what will be the instrument then? The next question, if we take this money from the accounts, can we identify why this money was there and who is to blame? So you provide this instrument to some people, but maybe the General Prosecutor's Office and the General Prosecutor can identify how this money left, where they are frozen, and can we hear the names of people who are involved? Because for second year we hear about Ms. Gontareva, who maybe knew how these funds were frozen in Oshad Bank, but we are going in circles and we are waiting for the instruments. Could you give us, please, the answer to this question? So if they don't vote, so another Supreme Council will vote. So this will be one more signal. As to another question, confiscation of these funds to the state budget doesn't mean that criminal cases is stopped. When the criminal case had many episodes, Yanukovych, Arbuzov, Klimenko and others, in order to produce a verdict, all the episodes should be investigated. It takes time. Even in the countries of the European Union, such investigations, they're going on for years. And by this instrument, through civil process, we confiscate and funnel to the state budget those funds that have all the signs of being obtained illegally. And the instrument that we provide to the prosecutor's office is one more instrument to be effective. Yanukovych, Klimenko, Arbuzov, these are the names. And maybe the executors also, the names are known, and the Ministry of Justice is not law enforcement bodies. So, but we try to help our law enforcers. We provide useful instruments for them. As of today, the code provides prosecutor's office the opportunity to confiscate or to carry out special confiscation if the person found guilty in the result of the investigation. And in order to do this, it can take years to do this. And often, Yanukovych, for example, he didn't put money on his own accounts or property. For example, Mishagiria belonged to some firm, not to him personally. And in the criminal process, you should interview people, those people who live for several years in Russia. It is impossible, and some actions should be carried out, but the money is frozen, and in 30 countries people adopted such law. In Latvia, by decision of court, they confiscated 50 million euros that were on the accounts that the Latvian power believed that they are suspicious, that they were obtained illegally, and this money were funneled to the budget. And we should not ignore European approach to solving such problems. We should defend people, not corrupt officials, and we should adopt such a law and implement it. And I would like to say that Georgia, that is one of the examples. By the European Court, it was said that if in Georgia they didn't adopt such legislation to confiscate assets, Georgia wouldn't be brought up to at the rating up to 10 position. So we have not enough time. Please introduce yourself. Yulia Procession from your agency. I have a question to Geraschenko. First question. Previously, the European Union and the United States criticized confiscation of property without court decision. And what reaction can be expected now? And also, second, about those who are involved in corruption. We remember the situation with Geraschenko, and then NABA decided to investigate the case with his flat. And what about if, for example, this law, is it applied only to the previous corruption cases? So we didn't intend to seize the property without court decisions. This is just manipulation in the media. The draft law that is approved by the Cabinet of Ministers is created by specialists, and it is envisaged that in the framework of criminal investigation, the prosecutors see that there was a lot of contacts with persons, and these persons, they can be asked whether this property, this cars, this housing, this things come from. And if person provides the documents that are properly done, for example, if a person earned this property, there is no problem. He can show the contracts, and if he cannot provide this contracts, the property will be confiscated, but this person will not be brought to criminal responsibility, but this person and the corrupt official will be deprived of the corrupt assets. As to Sergei Leshchenko, no person can be guilty if this guiltiness is proved by court. Yanukovych and all his proxies, they were not convicted by the court. They are just the suspects, and of course people can give their opinions on the situation, but there should be proper investigation by law enforcers first. The last question. One comment. If this is government draft law, why Mr. Volokh is involved in this, and are you the author of this law, of this draft law, and why is so much attention to People's Front? And what about the support of other factions? VSTUA. In the Constitution it is said that property rights, they are preserved, but if some assets are gained illegally, so in the interest of people, the state can seize this property to the state budget. As to the development of such draft law, first draft law concerning this was introduced in September by some deputies, and the Rada didn't vote for this. Then they tried to approve such a draft law, but there were some differences. They envisaged confiscation and process, and there were some recommendations from the EU members. And in March, the working group was created, consisting of deputies, and Karl Volokh also was included in the group, and also experts of reanimation of packaging reforms and experts of counteracting corruption, Yanchuk and Shibunin. And the process was started, then this draft law was developed in June, and then we addressed to the European Commission on reforming legal system in order to obtain their view on this, and they endorsed this draft law, and there should be political decision, not the initiative of separate deputies, but the consolidated position to introduce this draft law on behalf of the Cabinet of Ministers. And I do not want glory. I want that Ukraine have special interest and to have special instrument to prevent corruption. Thank you. So this is the end of press briefing. Thank you and goodbye. Dear colleagues, our next